and I'm sure you'll all have some questions as Kelly's going through the presentation. So if you could just keep those with you, write them down, save them until the end of the presentation. We'll be closing out with a Q&A with Kelly. So we'll make sure to get to those. Just keep them with you till the end. And I believe that is all from me. So without any further ado, Kelly, go ahead and take it away.
All right. Well, good afternoon, everyone. Thanks for being here. There's going to be a lot of information in this presentation. It's very jam-packed. I want to preface, as we're going through this with, you're going to have a lot of questions. You're going to want to ask me some what if questions. And a lot of times my answer back to you is going to be, well, it depends. And I'm going to have to ask you a bunch of questions before we can get to an answer. Because while this law is going to probably apply to you no matter what type of business you have, it's going to have some nuances depending on what type of employee we're talking about or what type of business you have. So just keep that in mind. This is very general, but we do welcome all questions, like Chelsea mentioned at the end. So we'll go ahead and get started. And the first thing, we're just going to talk about how to classify your employees. And so, it's not easy. There's going to be a lot of misconceptions that I have seen prevalent in the construction industry, in the oil and gas industry, in the restaurant industry. You're not alone in probably the way you're doing it if you're making mistakes. So what you really need to start off with is, are my workers being classified correctly? Are they employees or are they independent contractors? And it's going to depend, that answer will then guide us on how you need to pay the people. So as we move along here, the federal wage and hour law is called the FLSA. It's the law that establishes minimum wage and overtime, but also some extra requirements. It's where we find that, you must keep records and how to keep timesheets and the proper way to pay overtime or to calculate a regular rate and things like that. So nearly every company is going to be liable under the Fair Labor Standards Act, or they have to comply with it. And so the first way is enterprise coverage. And enterprise coverage is, you got 2 employees in an annual dollar volume of sales or business of $500,000. And if that fits your description of your company, the wage and overtime laws automatically apply to you. The other one is individual coverage. And if you don't fit into that first one, let's say you're a new startup, let's say you're really small, whatever it may be, if the employee that is looking to hold you liable for failure to pay overtime is somehow involved in interstate commerce, then the wage and overtime laws apply to you. And this is, I know it's crazy, but it is seriously as simple as, let's say you're a painting company and you buy paint that comes from a different state. That crossing of state borders makes you involved in interstate commerce, and you have now been subject to the FLSA. Let's say instead you are painting, everything comes within Texas and you're painting a building, but this company now is going to function as a company that's going to manufacture products that go to different states. Well, now you're involved in interstate commerce. We can make arguments. I can make any type of argument. You say one thing, I'm getting you to interstate commerce some way or another. So I guarantee you that the likelihood is that this is going to apply to you. And so now that we know that it applies, well, what's next? What is the actual standard wage and overtime rule? It's simple, right? It's 1.5 times your regular rate for every hour you work over 40 in a work week. Everyone knows that. Everyone can repeat that. But if it was that easy, then wouldn't have jobs. So we've made it a little more complicated than that. And what we're really going to focus on here is the definitions of the words employee and the words exempt. And so if we start with what an employee is, you know, I would imagine that there might be some misconceptions of what you have deemed to be an employee. And Chelsea, I don't know if your screen's frozen or my screen's frozen. There we go. So you may think that you can determine if your worker is an employee or independent contractor. You may think that you're just going to offer the job, like a job position, right? You might be offering someone a reception job, a management job, a janitor job, a project manager job. We all understand that there's different job offers and job positions. And so a lot of people also think, well, I can just decide then a project manager is an employee and my laborer is an independent contractor. That's just part of the job position. But unfortunately, that's not true. The determination is actually made by the courts looking at a 5-factor test. The other thing that's the big misconception here is that your worker can decide to be the independent contractor. And that's not true either. And so they'll look at this 5-factor test and actually determine it. And so this is really what I mean when I say that. You may look at me and you can say, well, what if my guy does this or that? I'm going to ask you more questions based on the 5 factors you're seeing on your screen in front of you. Degree of control, permanency of relationship, skill and initiative required, relative investment, and potential for profit and loss. The courts like to act as if all 5 of these are equally important, but the reality is the most important one is going to be that first one, the degree of control. And so as we move along here, this analysis applies in Texas. I know I'm going to keep saying federal law, FLSA, and things like that. Texas does not have any additional or extra or separate wage and overtime laws. Texas has some payday laws, you know, that kind of govern, you know, when someone is let go, whether it's terminated or whether they resign, how and when you give them their paycheck. It governs how you can dock someone's paycheck for failure to return equipment, things like that. But Texas doesn't have any sort of extra protection. So if you're in line with the federal law, you're also in line with the Texas law, and we don't have to do 2 separate analyses. However, there are several states that have additional laws. California is one. I think Minnesota is another one. New York's another one. So if you ever cross state lines, you need to be aware of that, because if we get you guys in compliance in Texas and you think you're good and you keep that pay practice and now you've crossed over to a different state, it's as easy as a phone call. It's an easy way for an attorney that knows how to research those types of laws, and we can find fairly quickly for you if you've got some extra obligations. And so once we kind of pass that first hurdle, once we kind of talk through those 5 factors and we know if your worker is an employee, now remember, I don't care how much your worker has begged to be an employee. I don't care if they will only accept the job. None of that's going to matter. What's going to matter is those 5 factors and how the court looks at it. It also doesn't matter if you pay them with the 1099. That's not enough either. You didn't see, you know, payment method or 1099 in that 5-factor list because the court doesn't even consider it. So this next box here is, okay, we've gone over that hurdle. Let's say we pay him a salary, and then you may also think, I'm good, right? We see here that to be considered exempt, we got another box to check. The employee must both be paid a salary and must fit into a next exemption categories. There's several: executive, administrative, professional, computer employee, highly compensated, creative professional. I believe there's additionally an outside sales exemption as well, but the one that I want to focus on a little bit here is the administrative exemption. And let's say, for example, you have a a receptionist, and that person is paid a salary, and that salary, you know, covers basically 40 hours a week. As long as that receptionist is only working, let's say 8 to 5 with an hour lunch break, never works a minute over, even if she works a minute under, she's still getting that salary, then, you know, we don't even have to worry about overtime because she hasn't jumped into that level of working more than 40 hours. You're fine. So that's the easiest solution. Keep everyone under 40 hours and then it doesn't necessarily matter. But if she's working 45, 50 hours a week and she's being paid a salary and she's not getting paid overtime, now we have to ask the question of, okay, can I now make an argument to fit her into one of these popular exemption categories? And the most popular one, I mean, she's obviously not an executive. She's not a professional. A professional is someone like myself that holds a legal license. It's someone like a doctor. It's a professional engineer that has a stamp. It's someone that's gone through all of those extra levels of education and testing and things like that. But an administrative exemption, that might be the closest one. But it is someone that has some discretion in the job. It's someone that, for example, can either hire or fire someone, or can give you recommendations about who should be hired or fired, and you listen to them. It's someone who can basically make managerial level decisions on a day-to-day basis without having to run them up the chain for approval. And it's discretion that is more than just following a typical checklist for their day. So let's go back to this receptionist example. The reality is if she's working 45 to 50 hours a week and you know, you're not listening to her for hiring and firing, she's probably pretty much coordinating schedules, answering phones, running errands, maybe maintaining supplies in the office, you know, things like that. That's not going to be enough for me to put her in the administrative exemption. So her job duties are not going to be enough for me to get you out of having to pay her overtime. So your solution there is switch her to hourly and pay her overtime, or keep her salary and make sure she gets that overtime bonus. Essentially, the math can get a little complicated when we start getting into this, but there are options there. There's not a one right way, as long as the route you choose, make sure that she's getting that overtime premium of 1.5 for every hour she's working over 40. And so this is the other really big misconception that I see. The first is that workers can choose to be independent contractors, or you can choose for them. And second, that if someone's paid a salary, I automatically am free from overtime. And both those are incorrect. And as we will see as we go on, both can lead to fairly high penalties. So Chelsea, we can go ahead and jump to the next slide here. So like I said, you know, the consequences can be high. So we're going to get into those. And a lot of them you may think, you know, this is going to be a lot of work to get in compliant. And I promise you, as we go through these consequences, you're going to start to see, oh, the risk reward here is just so disproportionate. You know, it's time to get in compliance because the risk is just way too great to run that risk in my business. So as we move forward, we're going to see several different consequences. So the first is that you're going to have a payroll, federal tax, or IRS audit issue. And what this means is for everyone that runs payroll and their W-2 employees, you know, you're paying a payroll tax that you're not necessarily paying for your independent contractors. And the government doesn't like to be shorted even a penny, right? And so when they realize you're paying people incorrectly, you have these payroll taxes that now you've owed the government that you've been shorting them for the last however many years. The big one, wage and hour overtime lawsuits. This can require you to pay an employee up to 2 years and sometimes even up to 3 years of every cent that you shorted them in overtime pay. So 2 years. And that can just be huge. You get exponential penalties because not only do you have to pay them back, you automatically double what you owe them because the government and the people who wrote these laws decided that this was just such a horrific violation of someone's rights that you have to pay them back. That should make them whole, but now you got to be punished, and we're just going to automatically double it. Not only that, but these employees can now collectively band together and all sue you in a big group. So instead of just having one person that you take care of, we can now send out notice and maybe 40, 50, 60. The biggest one I ever handled had to do with truck drivers or delivery drivers, and there was 100 in there. And so can you just think of the attorney's fees you're going to be paying your attorney to defend against and keep track of time records and calculations for just multiple people. The last one is a Department of Labor investigation, and this can happen a variety of ways. Most commonly, someone calls the Department of Labor and asks a question to kind of get on the Department of Labor's radar, but it is very possible that it is truly random. And they have offices all over the United States in multiple cities, and they'll just start investigating, and they'll just want you to turn over every record that you have to just, randomly make sure that you're paying your guys overtime. So as we kind of move through these consequences here, like I said, if the IRS, realizes you've been shorting them money, it's just a headache, right? It may not be that much money, but it's just something else to deal with that we could have prevented at the forefront. The wage and hour damages, like I just talked about, are going to be huge. You're going to pay my attorney fees to defend you. You're going to have the other side's attorney's fees tacked on to that as well, plus all of the penalties for having to pay someone. And then potentially just having them double and triple and quadruple because you're just getting more and more and more people joining into the lawsuit. So as we move on, I'll have some examples, to kind of show you real life examples of this. But the fact is, like I said, once you calculate the unpaid wages, let's say John left and you never paid John overtime. And after we do all the calculations, we realize that for the last 2 years, you owe John an additional $10,000. Automatically, you are going to get that changed to $20,000. The only way that can be stopped, and it is very rare and it is very narrow, it's almost, you would have to call the Department of Labor or write to the Department of Labor and ask them questions, give them your current pay practices, and ask them if what you're doing is correct. And then you'd have to get a formal letter back from the Department of Labor that they publish on their websites. It's not just like normal correspondence. It's like a formal memo that comes from them telling you what you're doing is correct. And then if a court of law finds that you're incorrect, you can just say, well, no, I got permission from the Department of Labor. I followed it to a T. You still owe the overtime because even if the Department of Labor got it wrong, you still owe it, but at least it won't be doubled. And I'm telling you, the Department of Labor is overworked and underpaid, and they're just not going to give you that type of go ahead or green light for your pay scheme. So while there's a way, not necessarily going to be something that's a reality. The second thing is that if you are caught violating the wage and overtime laws a second time, let's say you get popped for it and you get real lucky and only 3 employees join together and you get that taken care of, hands clean, you wiped it, that's done, it's settled, and you don't change your pay practices, because I promise you here at the Cromie's Law Firm, I'm going to be completely frank with you and I'm going to tell you what you're doing is wrong. Because I'm not going to let you just walk around blindly, and this is why. And it's because if you don't change it, we're just talking about having to pay John for 2 years and it was $10,000. Well, now, since you've messed up before and you didn't fix it and you knew better, now you have to pay John for 3 years. And that's going to be, let's say, $5,000 a year. So now that's $15,000. Well, now we got to double that. Now we're at $30,000. And so, you better learn your lesson the first time if something happens. And there's some arguments here. Let's say you're laborers and you got that right and you're paying them overtime and no one's an independent contractor and you just didn't know about maybe your receptionist or an in-house or an inner office employee. That's an argument there, right? Okay, well, I got popped before, but this is a different situation. I shouldn't be penalized like it again. And you may very well be right, but here's the problem with that is that I have to legally make that argument for you now. I have to legally file motions with the court or have calls or have hearings or whatever it may be. So you're gonna have to pay money to prove that you're right and you shouldn't go back into the third year. And the reality of what happens is that parties end up settling for 2 years and 4 months in the calculation, or 2 years and 6 months, or whatever it may be, in order to avoid those extra attorney's fees to make that argument to cut you off at the 2-year period. I'm happy to do it. And if I think you have a winning argument, sure, but this is all going to be about what is the best business practice for you. I mean, you just have to keep in mind that it's really more than just what you owe the employee. So as we can keep going, the Department of Labor. So I have seen this multiple times. The biggest ones that I had were actually restaurants, and they had an investigation. My client had 2 different restaurant locations. Both of them got investigated, and basically the DOL just made them open their books, made a determination that they weren't being paid correctly, and forced my client to have to come up with a calculation and pay. And the problem here is that the Department of Labor are trained individuals, but they're not lawyers. So it's a very different scenario than arguing in front of a judge who is a lawyer or against your opposing side who is a lawyer. And so sometimes maybe they don't necessarily get it right, or they may disagree. And that adds an extra level of just complication to the situation. The good thing here is what you don't have in the Department of Labor, if you're gonna make me find a silver lining, it's that means that the other side doesn't have attorney's fees that you're paying. So if you're in a lawsuit and the plaintiff has hired an attorney, you got to reimburse them for those fees. That really sucks. But the Department of Labor, like I said, are not attorneys, so you kind of can remove that category of damages. But we're going to talk here in a second why the Department of Labor is possibly one of the roughest situations that you can face. So if we go over to some real life examples, like I said, my Department of Labor, it was a restaurant, and someone had called and said, I don't think I'm getting paid correctly. And that was kind of a different scenario because, as we know, waiters, get paid like $2.13 an hour plus tips, and there was a tip out violation. And what the Department of Labor did was made my client turn things over. And then they calculated a amount that each employee was owed. And unfortunately, all of this took place before my client hired us. And so the calculation was already done. My client had already signed a piece of paper saying they'd pay it. I didn't really get a chance to go in there and try to delay it or resolve it or talk down the calculation or really engage negotiations. Unfortunately, I wasn't involved at that. And so what ended up happening is the Department of Labor just did their own calculation, then made my client pay each employee what they were owed. So my client paid it, they send the check off to the Department of Labor. The Department of Labor then contacts each employee and says, hey, you're owed $500, you're owed $3,000, come get your money. The problem here is, even if that employee just ignores the Department of Labor, never goes to gets it, you don't get that money back. Like I said, they just assume that this is just such a horrific situation and it's so punishing that they just keep the money. Eventually the money gets turned over after, I think, 2 or 3 years, gets turned over to the Department of Treasury, and you don't see that ever come back. And so again, the way that this gets prevented is we start from the beginning. So the second example that I have here has to do with kind of the notice requirement. And so Chelsea, there we go. So in this case, and this is not really any specific client of mine, this is a general that's happened with like 3 different people. And it's that first scenario we talked about, that first misconception where my client had let the employee choose if he or she wanted to be an independent contractor or an employee. And a vast majority of them, even within the same job description, you had several people who were employees, but you had several that chose to be independent contractors. And so, a lot of people don't know the wage and hour laws. If you are a sophisticated business person, logging in here and you're learning stuff, just imagine, your employees probably really don't know about any of this as well. So how are these employees even finding out that they're owed overtime? So this is what happened. Let's say an employee named John got injured on a job. Okay, well, everyone that gets injured probably knows they have rights, so they call an employment attorney. And I actually had my first job right out of law school was at a employment boutique. And every time we had a cold call, someone just calling to see if we could help them, I don't care what they were calling for. I don't care if they didn't even have a case or they had something like, I can't believe my boss fired me because I stole money. And you're just looking at them like, well, duh, they fired you. It didn't matter. We asked them the same 5 questions every single time. Who did you work for? How were you paid? How much were you paid? How many hours a week did you work? And what were your job duties? And those 5 questions told us if there was a wage and hour lawsuit or not. And that takes maybe 30 seconds, maybe a minute. And so if your employee is unhappy for any reason, whether it's because you've done something legal or illegal, or their manager cursed at them and they didn't like it, they think you're a jerk, none of those things are illegal, but they go and they call an employment attorney, and a good employment attorney is going to ask those 5 questions and is going to sniff it out. So once that happened, that guy filed a lawsuit against my client. And like I said, they're able to band together. And so that's exactly what happened. Notice was sent out to over 50 employees that had been employed over the last 3 years, even if they no longer worked there. And what that did is that exposure to my client was just astronomical, because what if all 50 of them decided to join the lawsuit and band together? And like I've said, sometimes, I've gotten really lucky and only 3 or 4 joined the lawsuit. And then, like I said, I've gotten really unlucky and there were 100 plaintiffs in one of my lawsuits. And so the more that join not only increases how much you have to pay them, it increases my attorney's fees having to keep track of that many people. And it puts a strain on your business, because I'm immediately going to tell you, okay, turn over every single time record for every single employee for the last 3 years. And now you've got to go pull all that stuff from me, and hopefully you have it. Because we'll talk towards the end here, that's a very important employment document that you need to have in your possession every time log. So thankfully, as we scroll forward here, there's been a couple of updates to this process. And so in mid-January 2021, the federal court, and that is the Fifth Circuit Court. So this is the federal appellate court that makes decisions that governs Texas, Louisiana, and Mississippi. This same result has not necessarily been reached by the other federal appellate courts that cover other areas of the United States. So like I said, if you're crossing state lines and you're not in Louisiana or Mississippi or the great state of Texas, you're going to want to double check, because this may not benefit you. So what I'm able to do now is make the class more narrow, or make the list of employees smaller before that notice gets sent out. Whereas before, almost immediately after lawsuit was filed, list of employees was, you were forced to turn it over. You had to send it out, even if I could argue, hey, like they're not the same job duties, or hey, I have different arguments for each of these workers. Courts didn't care, plaintiffs' attorneys don't care, notice is going out, everyone opts in, and then you have to make a second step of an argument that says, okay, look at all my evidence. Look, these guys don't do the same job. Or look how my arguments are different for Betty than they are for John. John was actually W-2 and did get paid overtime, kick him out of the lawsuit. Betty was never paid overtime. She gets to stay in, and you have this like fight. But the problem is now you have 50 employees who are aware that they could be owed overtime. Maybe they start talking, maybe it just snowballs. So this update, what this federal court did is essentially said, we're kind of getting rid of step one, and what you get to do for step two is now really the only step for certification of this big collective class. So now you get to do discovery, which is our fact-finding procedure. Now you get to actually make arguments that I will listen to. So maybe the reality is we shouldn't be sending out notice to 50 people. It really should be 30. And only that 30 would get the notice, would be able to opt in. And so why is it so important? It's so important because if an employee opts in, let's say the lawsuit gets filed January 1st, notice gets sent out, an extra employee doesn't opt into your lawsuit until March 1st. Well, how do we then calculate that 2 years I was talking about? Well, it's based on the date the employee joins the lawsuit. So if the employee joins March 1st, 2021, we're looking back at how much that employee worked for you all the way back to March 1st, 2019. So that every day that you delay sending out notice to the employee, and then every day that employee delays in opting into your lawsuit, starts to cut off those damages. Because instead, let's say the lawsuit was filed January 1st, I'm able to push this down the road until September, October, November, and now finally December 1st, 2021, someone has opted in that worked for me in 2019. I now only have to look back to December 1st of 2019. So even though in that first example, if they had opted in March 1st and they worked for me March, April, May, June, July in 2019, I would have had to pay all that. But now, because I could push everything back, and now that date is December 1st, 2019, even though they worked for me those other months, it's not going to be in the calculation. As of now, that's the reality of how this decision plays out. I have to imagine that as this goes into practice, the courts are going to come up with a different sort of rule so that I can't game the system, to kind of start cutting off other people's damages in the background or the later years. So the answer here is like, we're not quite sure, but if something happens right now, you could breathe a little bit more. There's a better chance here that I would be able, for any case filed after January of 2021, be able to kind of game the system a little bit, because the law is a little slow when it's trying to catch up to itself, when it realizes it's made a mistake and something needs to get fixed. So I don't know that this will be a permanent benefit to the employer, but there was definitely a shift from this law deeply favoring employees to now kind of favoring an employer a little bit more. It's not great. You still have a bunch of exponential damages here, but at least, we see a shift to help you guys out. So as we keep going, we're gonna change some topics here to a pretty common topic I get asked, non-compete clauses. And everyone kind of knows that term, they've heard that term. So a restrictive covenant is the big fancy legal term that we use. It covers non-competition agreements and non-solicitation agreements. And what they do is restrict your worker or your employee from competing against you, taking your clients, taking your employees when they leave your business. There are drawbacks with them. And that is because Texas prefers and encourages competition, right? We are not only just a nation that is built on capitalism, but a state that really enjoys really favors people being able to compete against each other, right? Let the best man win. And so they have made it that you have to be very, very tailored and very, very narrow with a non-compete clause in order for the court to enforce it. So there's three things. It's time, geographical area, and scope that the court looks at. As far as time, I mean, I rarely see more than a year. Sometimes you can squeak in 18 months, but the reality is you're not going to get to prevent someone from competing against you for longer than that, because the other side of it is someone's got to be able to earn a livelihood. And if this is all they know how to do, they have to be able to go do it. Geographic area, it's small. It can depend on the job description of the person you're trying to limit, but you're not going to be able to limit them to 50 miles or maybe even 25 miles. It may be 5 miles. It kind of just depends on what that person did for you and how you're able to restrict them. And then scope of activity. This one's a little easier. It's just that you have to restrict a person from doing an identical job for someone else. So let's say you are ABC painting, and now someone has left you and they're going to 1, 2, 3 painting. And you're like, okay, we're direct competitors. I've only limited them for a year in the same geographical area that I do work in, let's say just like Harris County or something like that. But what happened is this person used to be in sales for you at ABC, and now that they've moved over, they're actually in accounting. Well, now they're doing a completely different job, and so they're not really competing against you because they are running numbers or running payroll or paying checks and bills and credit cards and things like that. And so there's no true competition. So you would only be able to restrict this person from going over to 1, 2, 3 painting and being a salesperson for probably a year or so. So here's an example here we have on our next slide. And so regarding territory, so salesperson, it's one of the ones the law has already kind of figured out. And if a salesperson typically worked in Harris County, that's an easy geographical region to prevent them from working in, Harris County. And only if it's really the same product and it's really the competing market. So let's say you are painting and they go over to another painting company, but you only paint commercial and the second company only paints residential. Well, you guys aren't going after the same clients. So there's no real need for the non-competition there. Now, however, an upper level executive that's in charge of the state of Texas, you might be able to prevent them from doing the same thing for the state of Texas. Again, though, you don't just get to check this box. Everything kind of intertwines with each other. So is it really truly a competing business? Is this upper level executive doing the same thing? Or instead, are they now managing the finances as the CFO? Or are they a manager of the accounting department instead of the sales department? Whatever it may be, it has to kind of be that this person has left and gone into a mirrored or nearly identical situation with someone who is a truly direct competitor. So the easier thing that can be prevented is usually you can prevent specifically a salesperson or a worker from taking your clients, customers, or employees from you. So if you have a salesperson and they typically worked with customers 1 through 10, they can be prevented from usually about a year, but they can't in that year go call on customers 1 through 10. They also can't go and tell their new employer, hey, I'm not going to do it, but here's a list of people I used to work with, go call them. Can't do that either. If your agreement is drafted correctly, that's prevented. That's a non-solicitation. Anytime you're preventing someone from going after a customer, employee, or your own personal clients and things like that, that's a non-solicitation. Now, let me be clear here. This is not the only way to protect your business. And they can be a very expensive way to protect your business. And another level here for everyone to remember is A non-competition and a non-solicitation agreement can be put on one of your individual employees or your individual independent contractor. If you are someone who is a subcontractor or even maybe a general contractor, and you have people below you in the chain of command on a construction project, such as a supplier or a smaller subcontractor you typically contract with, you can't do a non-compete or a non-solicit on a business. It has to be an individual. We can protect you in other ways based on your contract with the business, but this is not going to work in that scenario. You can only restrict your employees. So as we keep going here, the problem is these get very expensive very fast. As you see here, you're going to, in a few weeks to maybe even a month, you're going to have to pay me $10,000 to $20,000 to get a court to agree to restrict someone from doing something. But the likelihood is if the court finds that your agreement is just slightly unreasonable, you're not going to get any money. All you're going to get is the court's going to look at your document. They're going to take a pen, they're going to redline it and edit it and just hand you back something that it feels is enforceable. So you've spent a lot of money to get a piece of paper to get someone to stop doing something. And so it's not necessarily the best economical decision for a business. So as we go forward to best practices here, we're going to look at some other ways to save your business time and money to keep you better protected. Because the reality is these agreements are not the only way. Even if an employee never signs a non-compete or a non-solicit with you, there are still ways to protect yourself. So if we move forward here to what those are, the first one is the Texas Uniform Trade Secrets Act, or fancy TUTSA. And so this is the easy way that the law is going to protect you from taking a trade secret. And so you might be thinking, okay, well, there's nothing special about, the way my paint is made, or I don't have some secret recipe for some secret sauce. But the law has already established that customer lists, pricing lists, suppliers lists, methods are things that are trade secrets. So if you have someone that, downloads or takes with it, or even mentally memorizes a list of clients, they've stolen a trade secret. So they can be liable for that. Then if they go to their new company and that new company starts using this stolen trade secret, that company is also liable for misappropriation of the trade secret, using something they had no right to use. So as you can see, that's going to already protect your business, like clients and customers, to the extent that we can prove this employee took a list that didn't belong to them. And pricing is a big one in the construction industry because it's affecting how you're bidding a project. And then someone can take that and go underbid you by $5 and win a project. That's highly unfair and is not true competition that Texas favors. So that's kind of the easier route to go, and one I typically advise my clients that they always have. Doesn't mean they can't still sign those agreements, just to maybe put them on notice or scare them from competing against you, but you need to know that this is the fallback and probably the easier route. So the second thing that can be done is tortious interference with a business contract. So you all know, hey, I'm going to sue so-and-so for breach of contract. Well, I can also sue someone for interfering with my contracts. So like you can read the example here. I'm sure that you'll be able to get it on the slides. We're running out of time here, so I'm not going to go through it. But basically what this means is, you have standing contracts or maybe standing agreements with certain businesses, and now all of a sudden they're not working with you anymore because one of your employees left and took them, or started a new company and started to take them from you. Well, that employee knew you had a business contract with that person, and now they've induced that person to break that contract. They can be liable for that. So our third option over here is confidentiality agreements. And so these are typically what I recommend. And, you know, it's already something that can kind of cover the trade secrets that we already discussed. You're already protected. But what this does is it kind of puts that in front of your employee as well. Tells them to be confidential, and independent contractors and employees alike can sign this. It can be tailored to each worker's job position, right? So maybe someone who's in accounting, you should remind them, hey, keep payroll, keep salaries, keep how much we make, our profit, our margins, you know, things like that confidential. Whereas your salesperson needs to keep price lists, customer lists, how they bid, how they put together a lid, if they're a bid, excuse me, if they're an estimator, you know, things like that. So you can tailor it per job position. And then also I like to throw in there those non-solicitations that we talked about. Hey, don't touch our clients. If you leave, don't touch our employees. And while you're already kind of protected, it reminds the employees that when they leave, oh, I have for a year, I have to mind my P's and Q's and I have to comply with this agreement. And so the non-solicits are the easier ones to enforce in court. And so that's why I kind of like this nice, clean agreement. People are more willing to sign it. You know, people kind of balk at anything that says non-compete on it. So this would allow a salesperson to go work at your competitor. It just prevents them from stealing your actual business from you when they do leave. And courts tend to appreciate that more than situations where you're trying to prevent someone from earning a living. We can keep going here. So as I said, it's going to be very important that you keep proper documentation because it's going to prevent issues coming up in the future. I know it's a hassle, but I promise you it's going to be worth it. So as we move forward to important employment documents that every business should have, this is not an exhaustive list. There's more. You know, we can build all of these for you here at the Chromians Law Firm. A lot of them we do offer, you know, flat fees for, such as the employee handbook. And if we keep going, we're going to kind of walk through an example of why these are so important. And so I know that most of my clients, if not all of them, never intend to discriminate against anyone. You just say, this person's doing a bad job, they get fired. But the reality is, and I've been on both sides of these wrongful termination cases, that it's very easy for the plaintiff to check his first box and say, I've been discriminated against, because all they have to do to check that first box is kind of make it seem like, maybe there was something fishy here, or I wonder what the true intentions of this firing really were. And that's it. That's all they have to do. And so as we go forward here, we're going to go through a little example. I'm sorry, maybe my example is not quite yet, but we'll get there. Performance reviews, you know, not only allow you to measure progress of employees, but it'll back you up when your employee has been terminated and can paint that picture of, I am a Black individual, I got fired and my replacement was white. That looks like discrimination, and that's it. That's all that has to happen. Now, let's say you got this employment review and you're saying, no, I actually fired him because he was always late, and you have performance reviews or progressive discipline forms to show this person got written up, got talked to. You have the timesheets to show why they were actually late and they were consistently late. Well, that shows that legitimate business reason of why they were fired. So you may now think, great, good, perfect, analysis over. But the problem is that it's not over, because as we keep going here, what then happens is the back and forth is still going to go on. Like we see here in this middle paragraph, you know, we just talked about it. You've shown your legitimate, non-discriminatory reason for why this person was fired. But now the employee gets to one more time take a swing at you and say, well, actually, this legitimate reason is actually a lie. And so now we're going to go back and forth, and it's really going to depend on a lot of your paperwork. So for example, like we just talked about, well, no, I fired you because you were late all the time and you never came in the proper dress or things like that. For this one, you know, it's a female saying, I was replaced by a male and you're telling me it's because I was tardy. If you don't also have the employment records or the time records for all the other people in the office, let's say this female, let's say she was a receptionist and she got fired, and we're saying, well, she was late. But she can be like, well, look at all these other male employees. They were late too, and you never wrote them up. So clearly you're favoring one gender over the other. And see, this back and forth just gets very expensive, and it can heavily rely on the documents. And what typically happens is it goes all the way down to having to get in front of a jury, because very rarely can I get one of these cases out on a motion for summary judgment. And what the jury, you know, they're everyday people and they're going to have biases. And all they have to really do is think, this person's gender, this person's race, this person's religion was one of the factors that led to their termination. Doesn't have to be the only factor, doesn't even have to be the most important factor. If a jury finds that it is one of the factors, there's going to be a case for discrimination. So that's why paperwork is so important, because instead what you would then have is just dueling testimony between, you know, you as a business owner and an employee. And that's really in the hands of a jury, and they will like someone for the craziest reason. They will be like, well, I liked her hair. The other guy's suit was wrinkled. He's lying. Juries will come up with crazy reasons to believe people. And so how do we circumvent that is having the proper documents to also put in front of the jury. So as we keep going, I think we're almost here to the end, and I promise I will stay here if you guys have questions past 1 o'clock. Oh, good. We got a little 4 minutes early here. So as y'all see, there's our number, there's my email. For those of you who aren't already existing clients of us, we offer free hour consultations. And so if you have something very specific to employment law, I really encourage you, give us a call, send me an email, let's get something on the books, because as you can tell, a lot of it is going to depend on the facts of who you are as a business and who your workers truly are. So with that, I will open the door to some questions.
If you have any questions for Kelly, just feel free to unmute yourself and ask, or send them in the chat and I'll ask for you. Any questions? If not, we'll go ahead and close this out.
And I'll tell you guys, a question may pop into you, you know, tonight while you're eating dinner, tomorrow when you're on the way to work, whatever it may be. If you don't ask it now, ask it later. Always ask the questions, because as we talked about, these penalties can just be astronomical, and I don't want you in those situations. So as always, feel free to reach out as we close out our webinar.
We'll make sure to send you guys a follow-up with the presentation, as well as Kelly's contact information if any questions do come to you. Thanks so much for joining us today, guys.